We turn now to performance and breach. We've discussed sales and lease contracts, terms, and what makes it a contract. We discussed who bears the risk of loss and when a party is said to take title. Now, we turn to the heart of the deal, the performance by the parties and when a breach occurs. So performance. When you get right down to performance of a contract, of a sale, that's what the law of sales is all about. We could talk about abstract theories and legal constructs. They're all well and good, but what really motivates the parties is the reason why they expend the energies to get into the contract, right? It's about entering into the arrangement, and each has managed to get from the other a binding legal commitment. The seller is legally bound to hand over goods and to stand behind whatever he or she has sold, and the buyer is required to take the goods and pay for them. Should either fail to do what must be done, the other will have the support of the courts in getting a remedy. So the duty to perform is at the very heart of contract law. And to understand performance, it's necessary to know the duties and the obligations each party has assumed under the terms of the contract. And the UCC, the basic obligations, are that the parties act in good faith and commercial reasonableness. That's what underlines every contract. So for example, a contract may specify the city in which goods are be delivered, but leave open a particular address. Who would be obligated to provide the address? The buyer. The buyer is obligated to specify the address before the delivery date, and if the buyer fails to do so, can the seller be responsible for any delay? No, the seller is excused from any resulting delay. So there are basic obligations that each of the parties have, and we're going to go through those. So the basic party obligations, we already talked about an example, so let's talk about the seller obligations. What are the obligations of the seller? General duty of the seller: to make timely delivery of conforming goods to the buyer. And again, I want to remind you, when I'm talking about seller-buyer, I'm also talking about lessor and lessee. I'm just not going to use them interchangeably. So, seller has to deliver goods, conforming goods, to the buyer. Okay? What are conforming goods? They have to match the specifications in the contract. 1,000 red iPhone cases, not 1,000 blue iPhone cases, right? Those would be, the conforming goods would be the red iPhone cases. And what's delivery? We have this timely tender of delivery of conforming goods to the buyer / lessee. So what's delivery? You have to get the goods to the buyer with notice. Okay? The seller's act of placing conforming goods at the disposal of the buyer and providing whatever notification is reasonably necessary to enable the buyer to take delivery. So goods to the buyer with notice to the buyer. So we have delivery of timely tender delivery of the goods, obligation of the seller. So for example, Dairy Products Inc., the seller calls grocer, the buyer at 2 a.m. and says, hey, goods are ready. I'll give you 20 minutes to get here. Is this tender of delivery? Well, we have to consider about the timing of delivery. There's also a consideration that the seller has to give. Whatever the parties have agreed to, obviously, that fixes the place and time. So you deliver on March 2nd at noon in the agreement, but if it's not in the agreement, like in this situation, the UCC says tender must occur at a reasonable time and in a reasonable manner on good faith and commercial standards. So, is this reasonable time and reasonable manner? No, unless they have agreed to that, but the goods are to be tendered at a reasonable hour and time and kept available for a reasonable period of time to enable the buyer to take possession. So, timing of delivery is on the seller's obligation. So we have this rule Regarding delivery, all goods called for by a contract must be tendered in a single delivery unless the parties agree otherwise or the circumstances are such that either party can rightfully request delivery in lots. So, what does this mean? Trend Fashions Company, who's a buyer, contracts with off-the-rack clothing, the seller, and purchases 1,000 shirts with the American flag on them. Can the rack clothing company ship the shirts 2 at a time as they're made? I guess the parties can agree to that, but no, the parties can agree regarding their shipment, but no, this is not reasonable. How about if the parties agree that they be shipped in lots of 4 of 250 shirts each? They can agree to do that. But if there's no agreement, everything has to be shipped in one single delivery. So that's how to deliver. So the seller's obligation of delivery is they have to deliver the goods, and it has to be done at a reasonable time, in a reasonable manner, and it all has to be done in one single delivery unless the parties agree otherwise. So here's our example that I was just talking about. Under that example, shirts can't be shipped 2 at a time. Of course, the parties can agree that they be shipped in lots, and I gave the example of 4 out of 250. But if it's not agreed upon, all 1,000 shirts have to be delivered in one single delivery. So now we turn to place of delivery, if it's not specified. Obviously, the contract rules. If it's specified, then it's specified. But if the contract does not specify the place of delivery, the UCC has provided for the place of delivery. And the seller's obligations are dependent on whether we're dealing with the non-carrier cases, those goods that are non-movable, where the buyer picks up or they're stored in a warehouse, or carrier cases where the seller has to put, what we have a carrier involved in, whether or not it's going to be a shipment contract or a destination contract. So let's turn to place of delivery. So non-carrier cases where the buyer's picking up. What's the designated place in the seller's? The designated place would be the seller's place of business, and if there is none, the seller's residence. The goods have to be, where we have a warehouse situation, the goods have to be identifiable. They are identifiable goods in a warehouse. We got the parties know that the goods they're at the location at the time of the contract. So the delivery of goods is they're identified, and they're located in the warehouse, and the parties know this at the time of contract. That's the delivery. Don't confuse it with when the buyer takes title and the risk passes. We're talking about the delivery. Okay? So the seller's obligations are going to depend on what type of contract, whether we have shipping or destination. I want to do this example before we turn to carrier cases. Arnold Moneybucks goes into Stella's art gallery to view a show of recent works by a contemporary artist. He spots one small painting, black on black, which he decides to buy and enters into a purchase and sales agreement with Stella. The agreement provides that Moneybucks will pick up the painting in a few weeks when the artist's showing is over. So this is Moneybucks who's going to pick it up. When does identification occur? At the time the parties enter into the contract. When does title pass? At the time the parties enter into the contract. Who has the risk of loss? That'll be Stella, because she is a merchant. And as long as the merchant retains possession, the risk of loss stays until the buyer picks up. And delivery. When do we have delivery occurring? In this instance, in a few weeks, when the artist shows over and Stella says that Moneybucks can come pick it up. Stella telephones Arnold on a Friday to tell him that the show is ending on that day. She tells him that he can come into the gallery and pick up his painting. Has Stella tendered delivery. No, she hasn't tendered delivery because the buyer has to come and pick it up. She's made it available for him to pick up. Suppose instead that Stella's contract with Arnold provides that she will deliver the painting to him. On Saturday, she wraps the painting up, puts it into her delivery van, and drives to the address Arnold has given her. The address turns out to be Arnold's business office in a large office building. No one at the building is willing to accept delivery of the package on behalf of Arnold. Can Stella claim that she has tendered delivery as of this point? Probably not. She's delivering on a Saturday. Again, we got to note that tender must be at a reasonable hour. Stella will have to make the delivery during normal business hours, or at least sometime when it would be reasonable to think the delivery would be accepted. She had his business address, not maybe a residential address. So would there be any argument on the other side? Maybe if she asked Arnold, where does he want it delivered? And he says, at my office anytime. That might allow her to say that she made reasonable tender. But these are the things you kind of have to think about when you're seeing a delivery. It's reasonableness, reasonable time, reasonable manner. Assume that black on black is not a small painting, but is in fact rather large. Assume further that Stella has agreed to deliver this monster canvas to Arnold's home, a quaint townhouse in a fashionable part of town. When Stella and her workers arrive with the painting, it soon becomes apparent that there is no way this painting can get through any of the doors into Arnold's house. Stella has to return the painting to her gallery, where it now sits. Has she tendered delivery? Has she tendered delivery? Yes, she has tendered delivery, especially if that's where she was supposed to deliver it. The fact that it doesn't fit in his house, that's on Arnold, but she has in fact tendered delivery. So carrier cases, and that's going to depend on whether we're dealing with a shipment contract or a destination contract. As you remember, under the shipment contracts, it's required that the seller ship goods by carrier and leave them in the hands of the carrier. That constitutes shipment. On the other hand, destination requires the seller to deliver the goods to a destination. So, shipment contract, this is what we need. The seller can't, when I say in the hands of the carrier, that does not mean here you go. Like the seller has some obligations that they have to do, okay? They can't just leave the goods on a docking platform with an address on it and we're good. They have 4 duties relative to the shipment contract. They have to place the goods in the hands of the carrier. They have to hire the carrier and make arrangements, like have a contract for the goods to be transported, and they have to do it within that's reasonable according to the nature of the goods. What do I mean by that? And their value, I should say. Reasonable transportation that is reasonable according to the nature of the goods and their value. What do I mean by that? If the goods require refrigeration, they better have refrigeration in the transportation. Tender appropriate documentation to the buyer. So they have to obtain and promptly deliver or tender to the buyer any documentation necessary to enable the buyer to obtain the goods from the carrier. Usually a carrier will give the seller the bill of lading, and that's what the seller turns over to the buyer. And they have to promptly notify the buyer that shipment has been made. That means they put it in the hands of the carrier, they got the appropriate paperwork, and here is the paperwork, and I'm notifying you. That's their job, okay? I have a separate example on this, so you can listen to that. It's on the sheet, and work through these, an example of how that works. So if the seller does not do all of these things, and there is a loss or a delay, the buyer can reject the shipment, okay? So check out the example and work through that. Destination contract. Seller agrees to see that conforming goods will be duly tendered to the buyer at a particular location. Okay? The obligations relative to this. The goods must be tendered at a reasonable hour and held at the buyer's disposal for a reasonable length of time. And the seller must provide the buyer with appropriate notice and any documents from the carrier. So the buyer needs to know that they are there and they are arriving. Again, I have an example that's dealing with the shipment contract, the destination contract, and then the next rule that we are going to talk about. We have this concept called perfect tender rule. And the perfect tender rule means that the goods and the tender of delivery must conform to the contract. If either fail, the buyer can accept the goods, can reject the goods, or can accept parts and reject parts. That's the buyer's options if the goods are non-conforming or something was wrong with the tender of delivery. However, with all cases, there is an exception, and there's an exception to the perfect tender rule. The perfect tender rule does not apply if the parties agreed that defective goods will not be rejected if the seller is able to repair or replace them within a reasonable time. And I want to point out that this only refers to the goods, conforming goods, not the delivery aspect, the goods aspect. So it doesn't apply if, one, the parties have agreed in their contract that defective goods will not be rejected if the seller is able to repair or replace them within a reasonable time. We call this concept cure, when the seller has an opportunity to cure. And that's the seller's right to repair, adjust, or replace defective or non-conforming goods. But how it works is when any tender or delivery is rejected because of non-conforming goods and the time of performance hasn't expired, the seller can notify the buyer promptly with intent to cure and can do so within the contract time for performance. So you have to know that the performance time hasn't expired in the contract yet and that the seller can cure within the contract performance time. So buyer contracts with seller for red, white, and blue striped t-shirts for a 4th of July parade with a due date of July 1st, and seller sends red, yellow, and blue striped shirts that were delivered on June 30th, and of course the buyer rejects those. Can the seller, and if in their agreement the seller is allowed to cure, can the seller cure in this instance? If it can do so within 1 day, because the contract will expire on July 1st, and the seller would have to cure within the time before the performance expires. If performance time has expired and the seller has reasonable grounds to believe that the non-conforming tender would be acceptable to the buyer, then the seller can still exercise a right to cure. So now we have an exception within an exception. In the past, Ready Electronics frequently allowed the Topps company to substitute certain electronic supplies when the goods Ready ordered were not available. Under a new contract for the same type of goods, Ready rejects the substitute supplies on the last day Topps can perform. Does Topps have a right to cure? Yes, based on that rule that I just said, Topps had reasonable grounds to believe a substitute would be accepted because they did it in the past. Topps can cure within a reasonable time, even though conforming delivery will occur after the actual time limit for performance allowed under the contract. So he has a reasonable time to do so, even though the performance time has expired, because Topps had reasonable grounds to believe that the non-conforming goods would be acceptable. So here's my rule with regards to the reasonable grounds, even though performance time has expired. Why do we have this right to cure? Why have it? What does it do? The right to cure restricts the buyer's rights to reject, right? If the buyer is rejecting goods for non-conforming, The buyer has to do something. He just can't say, yeah, I reject those. Those non-conform. If there's this right to cure option, it kind of restricts them a little bit. So if the buyer is rejecting goods for non-conforming and must disclose the nature of the defect, act in good faith, and state specific reasons for refusing to accept the goods, or they later cannot raise the defense that the goods were defective. So they just can't not accept them and claim that they're non-conforming. They must disclose the nature of the defect, and they must act in good faith and state the reasons for refusing them. We have a few more rules regarding delivery. When instances arise, other delivery rules I like to call them. Substitution of carriers. If the agreed upon manner of delivery becomes impracticable, which we'll talk about, or unavailable through no fault of the parties, then the carrier can be substituted, but you need a commercially reasonable substitute. That is sufficient. You can't, if you're using tractor trailer truck and for whatever reasons it becomes unavailable or impractical to use, you can't use an Amish buggy. Maybe you use airline or FedEx Air or something like that. We also have a concept called, with regards to installment contracts. It's a single contract, but the delivery is in 2 or more separate lots and paid for separately. We kind of discussed this when I said that if the contract does not specify the delivery all has to happen in one single delivery, well, this is an instance where we have a contract. We call them installment contracts. It's a one contract, but the delivery is coming in 2 separate lots, and they're paid for separately. So we call those installment contracts. So let's talk about what happens on those. Seller refrigerated appliances is to deliver 15 freezers in 3 lots of 5, each to buyer home appliances. In the first lot, 4 freezers have defective cooling units that cannot be repaired. Can home appliances reject the entire contract? And the answer is yes. With the rule, the buyer can reject the entire installment contract only if the conformity substantially impairs the value of the installment and cannot be cured. Here we have the 4 freezers that cannot be fixed, so they can't be cured, and clearly it substantially impairs the value of the installment because you don't know how the other 11 freezers are going to be. And if they are the same, they cannot be cured, or if they're questionable, being able to break down and not be repaired, then certainly affects the value. So you can reject the entire contract, but only if the conformity is substantially impairs the value of the installment and cannot be cured. We discussed impracticable contracts, or the ability to perform, along with impossibility under common law. Under the UCC, they don't recognize the impossibility, but they do recognize whether or not something's commercially impracticable. And it's the same concept. Unforeseen by the parties at the time of contract making that the performance is now impracticable, okay? And whenever, I'll give you the full definition. Whenever occurrences unforeseen by either party when the contract was made rendered performance commercially impracticable, the perfect tender rule no longer holds. Okay? The unforeseen contingency must be one that would have been impossible to imagine in any given situation. So it's slightly different, but if it happens, the parties are excused from performance. For example, a major oil company that receives its supplies from the Middle East has a contract to supply a buyer with 100,000 gallons of oil. After the contract is entered into, an oil embargo by the Organization of Petroleum Exporting Countries prevents the seller from securing oil supplies to meet the terms of the contract. Because of the same embargo, the seller cannot secure oil from any other source. Does this situation come under impracticable exception And it does. Actually, that was a real court case. It does, of course. The embargo must have been unforeseen by either party when the contract was made, and it was. So that would be an instance. Also, destruction of the identified goods must be through no fault of the parties and before the risk passes to the buyer. Then the parties become excused. So when goods are destroyed through no fault of the parties and before the risk passes to the buyer, the parties are excused from performance. That's kind of obvious, and I think that falls under impracticable. Where else would that fall? But it's two separate rules. So what happens if the goods are partially damaged or destroyed? Well, the buyer can inspect and can either accept with a reduced price, or they can just avoid it and reject the goods, avoid the contract. We have this concept of cooperation. Albert is required to contract to deliver 2,000 washing machines to various locations in Ohio. Deliveries are to be made on or before October 1st, and the locations are to be specified later by Farrell. Albert has repeatedly requested the delivery locations, but Farrell has not responded. On October 1st, the machines are ready to be shipped, but Farrell still refuses to give Albert the delivery locations. Albert doesn't ship on October 1st. Is Albert liable for any delay? I talked about this right up front. When I was beginning the topic of performance. No, he's not going to be liable. He's going to be excused for any reasonable delay. The parties are required to cooperate with each other. If you don't have a party cooperating, well, then might ultimately end up in breach, which will get us to our next topic shortly. But the next thing we're going to talk about are the obligations of the buyer. We were talking about the obligations of the seller. But we move on to the obligations of the buyer. Buyer's obligations. What might you think the buyer's obligation would be? How about to pay for goods, right? Well, they have to furnish the facilities suitable for receipt of those goods. They also have the obligation to inspect those goods and then make payment at the time and place the buyer receives the goods. So by payment, when they make payment, that means they agree with the goods. So if cash, seller has to give the buyer reasonable time to get cash. If they're paying on credit, they have to pay within 90 days. The credit period starts from the date of shipment. With regards to inspection, this is usually comes up, and we're going to have an example on those. Unless otherwise agreed to, the buyer can waive the right to inspect, but delivery happens at delivery. The buyer has an absolute right to inspect the goods before making payment. Why would we have that rule? Kind of makes sense, right? That allows the buyer to verify that the goods tendered conform with the contract. So make sure you look at your product before you buy anything on Craigslist. If the goods don't conform, they don't have to pay, right? So where does inspection happen? If it's not agreed upon at any reasonable time, place, and manner. And of course, reasonable is going to depend on what we're dealing with, right? The custom of the trade practices, the parties' past practices, and such. It's not going to be a clear-cut answer. It's going to depend on the circumstances and what type of contract and product we're dealing with. It might be something where the seller sends, a widget after building one. How does this look, right? 100 widgets delivered to buyer and pay within 60 days of receipt. Buyer can check them out during that time frame. I got an example coming up, a bigger example coming up. That's on the sheet that you'll listen to relative to that. Another example is what if the seller's building something big, like a specialty machine? There's probably going to be a number of inspections that the buyer's going to have to go through for each part in each process. So it's really going to depend, but they have an absolute right to inspect. When the buyer has already accepted the goods, but then withdraws the acceptance and seeks to return the goods, The next issue we're going to talk about, revocation of acceptance. This is going to tie into the example that's on the separate sheet. When can they do this? This can only happen if a nonconformity substantially impairs the value of the good and if one of the following factors happens. Acceptance was given on the reasonable assumption that the nonconformity would be cured and it wasn't within a reasonable time, or discovery of the nonconformity was difficult to discover before acceptance, or the seller gave assurances that the goods were conforming and that kept the buyer from inspecting the goods. Well, they're good. They're fine. They conform. So the buyer can revoke their acceptance after they have accepted goods. Maybe they inspected and then realized after accepting there was a nonconformity, and that nonconformity under this rule must substantially impair the value of the good, and acceptance was given on the reasonable assumption that there would be a cure and it wasn't, or discovery of nonconformity was difficult to discover before acceptance. And there is an example on this on the separate recording. I'd go through that and ties those last two concepts together.